welcome to Courts Today by Live Law. Let us get to today's top legal updates. The Punjab and Haryana High Court has said that Haryana's anti-cow slaughter law was meant to curb beef consumption, but alarming rise in litigation shows the state is not executing it properly. Opposing Tahir Hussein's interim bail plea to contest the assembly polls, the police has contended that he was the main mastermind and founder of Delhi riots. In the matter, the Delhi High Court has reserved the order today. In another Delhi riots case, the court wrapped police over clubbing FIRs and implicating the accused based on manipulated video. In an Ndps Act case, the Supreme Court has acquitted a driver of a taxi from which contraband was seized, saying that a taxi driver is not expected to give passenger details. The Supreme Court has issued notice on plea to include Rajasthani language as medium of instruction in Rajasthan schools. And consortium of NLUs has approached the Supreme Court for transfer of petitions in various high court regarding CLAT 2025. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before we start, let me tell you, Live Law Academy is offering a value-packed opportunity for the aspiring judges out there. The Judicial Service Examinations Preparation Course. This comprehensive online course is designed to help you prepare for your judiciary exams. The classes are conducted by expert faculty, including the retired judges. You would learn from actual case studies and other easy-to-follow study material. And you get all of this at an affordable fee. If you are gearing up for the judiciary exams, then you must check this opportunity. You can find all details at www.livelawacademy.com. The link has also been provided in the description. The course starts tomorrow, so do not miss out. The Punjab and Haryana High Court has expressed serious concerns about the rising number of cases under Haryana Gau Vansh Sanrakshak and Gau Samvardhan Act of 2015. The court highlighted that the act aims to curb cow slaughter and the sale of beef, but noted that the state is not implementing it effectively. Let me tell you, the act was enacted by the Haryana government to prohibit slaughter of cows and related activities while also ensuring the care and conservation of cattle in the state. In this case, the court rejected an anticipatory bail plea filed by a man named Khalid, who was accused of owning a vehicle used to transport cows for slaughter. Khalid's lawyer argued that he was falsely implicated based on the statements of co-accused and was not present at the crime scene. They also claimed that there was nothing to recover from him. But the state opposed his bail, stating that Khalid was identified as the vehicle owner and his interrogation was necessary to uncover his role. The court held that Khalid's absence at the scene did not automatically entitle him to bail, especially considering the serious allegations and his connection to the vehicle used in the crime. So his bail plea was rejected. Justice Sandeep Mudgal said that prime objective of the 2015 Act was to curtail cow slaughtering, consumption of beef menace emanating from powerful meat lobby consuming and selling beef for their own satiation. But the alarming situation with the increase in such litigations apparently shows that the state is not executing properly the act in its true spirit. In the next update, the Delhi High Court today reserved orders in the interim bail plea of ex-Aam Aadmi Party councillor Tahir Hussain in the 2020 Delhi riots case. The bail was sought from 16th January to 9th February to contest the upcoming assembly elections from Mustafabad as an AIMIM candidate. Hussain requested bail for filing nominations and campaigning. Hussain is accused in the murder case of Intelligence Bureau staffer Ankit Sharma during the 2020 Northeast Delhi riots. Ankit's body was found with multiple injuries, leading to charges against Hussain and others for murder and rioting under various sections of IPC and the Arms Act. His counsel, senior advocate Rebecca John, today said that in the PMLA case, he has already served more than half the period of custody and that he was not even convicted yet and might get acquitted in all the 11 FIRs. The Delhi police opposed his interim bail plea. Additional Solicitor General Chetan Sharma, opposing the plea, suggested custody parole for nomination-related activities but not for campaigning. He cited concerns about influencing witnesses and the seriousness of charges against Hussain, who faces allegations under UAPA and PMLA. Well, after hearing the parties, Justice Neena Bansal Krishna has now reserved the judgment, which will be pronounced in chambers. Moving ahead, a Delhi court has criticized the Delhi police for consolidating 6 FIRs related to the 2020 Northeast Delhi riots into a single case. The court observed that the investigating officer neglected his responsibility to thoroughly investigate each of the 6 complaints. The court also reprimanded the police for implicating an accused based on a manipulated piece of video. Additional Sessions Judge Pulastya Pramachala of Karkarduma courts referred the matter to the Commissioner of Police to make assessment of the conduct of IO and to take suitable steps. The case here commenced after Guru Tegh Bahadur Hospital reported the admission of an injured person named Shahrukh. He stated that a mob dragged him out of an auto during the riots, beat him with sticks and stones, and then someone shot him, injuring his leg and chest. The investigating officer clubbed together 8 complaints but only pursued 6, assuming the same mob was responsible for all. The court found that the IO only recorded statements and made site plans for 3 complaints but did little else to investigate. The IO even forgot about preparing the site plans and only admitted it during cross-examination. None of the 6 complainants witnessed their incidents and the IO did not verify their information or find the witnesses. The court criticized this sloppy investigation, noting that the charges lacked clear timelines and evidence, relying only on complainants' testimonies. The court also acquitted one Sandeep Bhati in one of these cases registered at Karwal Nagar police station. A video was used to identify Bhati, but the IO had edited the video from 7 to 5 seconds, cutting out the parts showing Bhati trying to stop others from attacking. The court strongly condemned this manipulation. The court said that it was clear that the IO did not investigate this case properly and the accused was falsely implicated on the basis of the video, and apart from that video, the prosecution had no other evidence against Bhati. The judge directed that since the task of proper complete investigation into the 6 complaints was to be completed, separate cases be registered and a final report of investigation be filed in the matter. In another update, the Supreme Court has acquitted a taxi driver who was wrongly convicted under the Narcotic Drugs and Psychotropic Substances Act of 1985 for failing to provide details about passengers who carried the contraband in his taxi. The court ruled that it is unreasonable to expect a taxi driver to know the details of passengers, and this alone cannot justify his conviction. The appellant here, the taxi driver, was convicted for carrying 20 kg of contraband ganja after 2 passengers who were in his taxi fled the scene when the police stopped the vehicle. Both the trial court and the Karnataka High Court had convicted him, sentencing him to 10 years of rigorous imprisonment and a fine of 1 lakh rupees. But the Supreme Court bench of Justices Pankaj Mithal and Ehsanuddin Amanullah observed that the driver was convicted merely because he could not provide details about the passengers. The court noted that taxi drivers generally do not ask for passenger details before allowing them to board. The court said that the prosecution had failed to establish a direct link between the driver and the contraband, and no efforts were made by the authorities to locate the fleeing passengers, which could have clarified the situation. Also, according to the court, the driver's behavior of remaining at the scene and the contraband being openly visible in the taxi supported his claim of ignorance. Therefore, the court set aside the previous conviction because there was insufficient evidence to prove the driver's involvement. Accordingly, the appeal was allowed and the taxi driver was acquitted. The apex court has issued notice on a petition seeking to include Rajasthani as a language to impart education to children in schools. Although the official language of Rajasthan is Hindi as per the Rajasthan Official Language Act of 1956, but the petitioners point out that Rajasthani is widely spoken by about 4.36 crore people according to the 2011 census. In 2021, the State Board of Education had issued a notification stating that the medium of instruction in schools will be Hindi or English or Sanskrit or Urdu or Punjabi or Gujarati. The petitioners here are aggrieved by the exclusion of Rajasthani. They argue that under Article 350A of the Constitution, the state must provide education in the mother tongue for children from linguistic minorities. Since Rajasthani speakers are a linguistic minority, the petitioners believe the state should offer primary education in Rajasthani. The petitioners emphasize that the issue is also a matter of preservation of cultural rights, and that the children speaking Rajasthani as mother tongue are suffering from discrimination because languages which are spoken far less as compared to the mother tongue are included in the Rajasthan eligibility examination for teachers, while the predominant language of Rajasthani is not. This SLP was actually filed against the judgment of the Rajasthan High Court, which rejected the petitioner's plea. The High Court had said that it could not issue a writ of mandamus to include the language since it was an educational policy matter. Well, now a bench comprising Justices Vikram Nath and Sandeep Mehta of the Supreme Court has issued notice to the state of Rajasthan, the Principal Secretary of the Education Department and the coordinator of the REIT exam, returnable within 4 weeks. Stay tuned. And lastly, the Consortium of National Law Universities has filed a transfer petition in the Supreme Court with respect to the petitions filed in various high courts challenging the results of the recently held CLAT exam for admissions to various NLUs. Petitions are at present pending in the high courts of Delhi, Karnataka, Jharkhand, Rajasthan, Bombay, Madhya Pradesh and Punjab and Haryana against the results of CLAT 2025, which was held in December. The consortium seeks consolidation of all the petitions and their transfer either to the Supreme Court or to any particular high court. Let me tell you, last month the Supreme Court had refused to entertain a petition challenging the answer keys of the exam and had asked the petitioners to approach the High Court. Also, a single judge of the Delhi High Court found that 2 answers of the exam were wrong and had asked the consortium to revise the results. A bench comprising Chief Justice of India Sanjeev Khanna and Justice P.V. Sanjay Kumar will consider the petition tomorrow. Stay tuned with me. For more information on the cases that I discussed, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel.